People often ask me, what is the purpose of alternative dispute resolution? If you're considering using an alternative dispute resolution procedure instead of litigation, or maybe you're interested in pursuing a career in alternative dispute resolution and you want to learn more about it, well, in this case, this video is for you. Because today, I'm going to answer the question of what alternative dispute resolution seeks to do, and I'm going to share with you 5 reasons why it's better than traditional litigation for solving disputes. And stay to the end, because I'm going to share my own experience with alternative dispute resolution, not as a mediator, but rather as a participant in a dispute. I'm Bob Bordone, and I've been writing, teaching, and advising about dispute resolution processes for more than 20 years. So let's start at explaining what alternative dispute resolution is and why it has emerged. First, just because, frankly, I do not want to keep saying alternative dispute resolution over and over again, let me just share with you that the common acronym that we use is ADR. Actually, for some people, when they say ADR, they mean appropriate dispute resolution. For our purposes, it doesn't really matter. What you need to know is that ADR is any consensual and non-violent method or process for resolving a conflict or a dispute that is not litigation. So when I say non-violent, I mean it doesn't involve war and it doesn't involve hitting you. Typically, ADR is one of 3 processes, either negotiation, mediation, or arbitration. The purpose of ADR is to provide people who find themselves embroiled in a conflict a greater range of process choices for how they can solve that conflict beyond either going to court or lumping it or fighting, whether it's through violence or at worst war. There are 5 ways in which ADR processes tend to be better for parties than fighting it out in court. So let's take each in turn. The first is party autonomy. Okay, autonomy, that's a really fancy word, but basically what I mean here is the capacity of individuals in a conflict to make choices for themselves or to be self-agentic. So most ADR processes actually give the parties in the conflict control to decide what their own outcome is. Instead of imposing an outcome on them, they have autonomy, they have choice. So here's why this choice really matters. Because typically when people are in a dispute, they're pretty sure that they're right and the other person is wrong. And therefore, they go into it thinking that a court will vindicate the fact that I'm right. And if you're in a dispute, you may well be right, or you may not be right. Because here's the other thing we know. We know that human beings suffer from all sorts of self-serving or egocentric biases. These are not intentional or manipulative attempts at overestimating our chances of being right. It's just how we are hardwired as human beings. So consider this research on something called final offer arbitration. So for those of you who don't know what final offer arbitration is, here is how it works. 2 parties are in a dispute, they can't agree. And so what they agree to do is submit to an arbitrator their assessment of what the outcome should be. The arbitrator can only do one of 2 things. He could either pick one side's submission or the other. The arbitrator doesn't split the difference in any way. And the idea here, of course, is that if you know that the arbitrator is going to pick either your offer or the other's offer, you're really incentivized to put forward the fairest possible offer. So in this research, participants are said you're going to be participating in a final offer arbitration, meaning you're going to submit your offer to the arbitrator. And then the participants are asked, what is the chance that the arbitrator will choose your outcome? Now, I know many of my viewers are math whizzes, and so you've already got the answer into your head. But for the tiny minority of you who are not math whizzes, let me tell you, the right answer is 50%.
Yeah, I'm sure of the math.
It's 50% because there are 2 submissions, right? One side and the other, and the arbitrator has to pick one of those. So that is 1 of 2, or 50%. Now, here's what the research shows. Even though the correct answer to this question Objectively, is 50%. Respondents say that on average, they have a 68% chance of the arbitrator choosing their submission. To be clear, this is objectively wrong. The answer is 50%. But what's happening here is that people are falling victim to this self-serving bias. And so one of the dangers of proceeding with litigation or court is that even though in your heart of hearts you think the court is going to be on your side because you think you're going to win, we know that we suffer from self-serving bias, and there is this chance, actually a 50% chance, that actually the court will be on the other side. So the beauty of ADR, the beauty of negotiation and mediation is we never have to surrender control of the outcome to some random third party because the parties themselves retain control of the outcome. Okay, so the second advantage of ADR is that ADR processes encourage creativity. Because most ADR processes encourage parties to look past positions to their underlying interests and needs, ADR opens up the possibility of creative outcomes between the parties. So when parties are in a dispute, they typically fall victim to something that has been called the focal bias error. So what is that error? Well, it is the tendency of parties in conflict to over-focus on the areas of disagreement and to miss the areas where they may have shared interests, differing non-competing interests, the kind of interests that serve as a source of creativity and value creation. Because negotiation and mediation and other ADR processes are more consensual in nature, because they are designed to help parties discover and discuss those underlying interests, the ability of those parties to harvest value-creating and creative outcomes is significantly higher. Okay, a third really big advantage of ADR processes is that there's an increased likelihood that parties will comply with whatever outcomes they agree upon. So whenever someone's in a dispute, getting a resolution is only part of the story. Once there's a decision or an agreement, that agreement needs to be implemented. So Tom Tyler at Yale and Paul Lind at Duke, along with other colleagues, have written on something that is called procedural justice. What their findings have shown is that when parties have a say in an outcome or decision, so when they're the ones crafting that decision, they report greater happiness with that outcome, even though it may be the case that they could have gotten a better outcome imposed on them from some outside party. Here's the additional important point. When the parties craft their own outcome, when they have a say in the outcome, the research has shown that they are more likely to comply or follow through on the implementation of that outcome. Of course, at a psychological level, this makes sense. If we have spent time and energy crafting our solution, we tend to like it more. And when we like something more, we're more willing to follow through. And so ADR offers advantages not just in reaching an agreement, but also in the compliance and implementation phase of that agreement. Okay, a fourth big advantage of ADR processes is that they tend to result in lower costs to the parties. So anyone who's ever been involved in a lawsuit knows that they are crazy, crazy costly. Voltaire was once known to have said, quote, "I have had 2 negative experiences with the law. In one, I lost a legal action. In the other, I won." I think what he's really saying there is that lawsuits are incredibly costly at every level. There's the financial cost, of course, of lawyers and expert witnesses. There's also the emotional toll of the waiting, right? Most courts are severely backed up and lawsuits can drag on sometimes for years. And the thing is, when they do drag on for years, frankly, most of them end up settling anyway. But the later they settle, the more time, the more money, the more energy has been spent to no good purpose. Typically, an ADR process, particularly negotiation or mediation, actually can bring about a better result at a lower cost and in less time. Lastly, ADR processes offer the possibility of restoring relationships, of rebuilding trust, and of promoting forgiveness and reconciliation. So, to be clear, there are of course many conflicts where none of the parties have any interest in reconciliation or reconstituting the relationship. But there's also a non-trivial number of disputes where, deep down, parties may really want to restore the relationship, even if they're not saying so. And of course, there are also situations where, even if the parties don't have a strong interest in restoring or renewing their relationship, the very nature of the situation forces them to continue to have some kind of ongoing connection. For example, in a divorce situation, it may be the case that neither party really wants to get back together, but if there are children involved, the parties will necessarily need to have some kind of ongoing connection simply for the benefit of their children. So mediation and negotiation and other specialized ADR processes such as restorative justice circles offer possibilities for reconciliation, forgiveness, and healing that litigation cannot offer. Some years ago, I was a participant in a mediation with a colleague who worked in a department different from mine. Neither of us, frankly, went into the mediation with a strong desire to build or renew our relationship. Prior to the mediation, we didn't have much of a personal relationship. I mean, we definitely would need to work together going forward because we were each supervisors of different departments. But there were also ways that we could do this with relatively minimal interaction going forward.
Don't ever speak to me again. We are finished.
But thanks to the skill of the mediators involved and to the goodwill of my colleague, we actually came away from this mediation with an increased respect for each other and an increased appreciation of why each of us had miscommunicated and really how we had gotten stuck. And over the next year, we actually found ourselves collaborating with greater frequency and ease. To my great surprise, 2 years later, when this colleague left Harvard to apply for a new position at another institution, she asked me to be one of her 2 references for the position. I was really honored by this, and for me, it was a reminder of the great power of ADR to transform relationships, even a relationship that frankly wasn't super important or deep, but it transferred this relationship from acrimony to mutual respect and admiration. Now, to be clear, ADR isn't for everyone, of course. But if you find yourself party to a conflict, before throwing in the towel, before escalating, before pursuing litigation, consider the advantages that ADR provides and whether or not it might be right for you. And if you find yourself in need of ADR services, especially negotiation consulting or mediation, I hope you'll reach out to me and my colleagues at the Cambridge Negotiation Institute. For now, keep on learning more about ADR by watching this next video, What Happens If You Don't Agree in a Mediation? And of course, don't forget to like, subscribe, and ring the bell. I'm Bob Bordone. Thanks for watching, and let's keep negotiating together. You don't have to agree to mediation, but you do need to keep watching the next video.